Hi, Kevin Keener with TrademarkComplete. This video is about the dreaded likelihood of confusion. So, once you file a trademark, an examiner takes a look at it and examines it next to other trademarks. If your trademark is too close to a registered trademark or a trademark that's in the registration process already, then you will get what's called a 2D rejection. That's section 2D. This is the likelihood of confusion section, saying that you cannot register a mark that is likely to cause confusion between consumers with an already registered mark. So, what does likelihood of confusion mean? This test is the most amorphous, malleable, just weird test overall to determine what would cause a likelihood of confusion. I have had some instances where I was absolutely certain that we would get a likelihood of confusion rejection, and I did not get one. There have been other cases where I was absolutely certain we would not receive a likelihood of confusion rejection, and I got one. So, it's kind of like reading tea leaves whether or not you will get a rejection on a likelihood of confusion. In my experience, the USPTO trademark office, the examiners are very conservative and are more likely to issue a rejection for likelihood of confusion if there's a mark that's even tangentially close. So, the test that is used to determine whether there is a likelihood of confusion is called the DuPont test, and that's based off of a case out of the Federal Circuit. There are 14 different factors to consider on likelihood of confusion. I will read them off because I do not have them memorized, and there are so many. So, the first factor is the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. Factor 2, the similarity or dissimilarity and the nature of the goods and services. So, just taking these two factors into account, these are probably the most important factors. The first is the similarity of the mark as to appearance, connotation, and sound. So if two marks are identical, let's say word is the mark versus word as the mark, those are identical. Word is identical to word. Now, let's say they are spelled differently. There's W-O-R-D and W-H-O-R-D. Arguably could be word and ward. Those are highly similar, though not identical. But if they were for the same goods and services, then a likelihood of confusion is likely to come up. Another factor is the similarity or dissimilarity of the channels of trade. This would be like if you are a brick or mortar location versus an online website. Those channels of trade and how you distribute your goods pertains to a determination of the likelihood of confusion. Factor 4 is whether your goods are likely to be bought by impulse purchasing. So, what is the care that a consumer is going to use whenever buying your good? If it costs a lot of money or is meant only for highly technical people, then they're usually going to take more time in discerning your product or service. However, if you've got a pack of gum that is located on the shelf in the checkout line, those types of products that are meant for impulse purchasing because they're so cheap and there's so many of them, then consumers are not going to care which one is which and not going to take the time to discern between the two. Factor 5, the fame of the prior mark. So this is, think of the Coca-Cola or McDonald's. How many people know the prior mark? The more people that know it, the better the chance the likelihood of confusion will be found. Factor 6, the number and nature of similar marks in use on similar goods. So this would be how many registrations are there that use word in my example when I said word. So if there are 2,000 registrations using word in some manner, then it is diluted. It doesn't have a lot of strength and meaning as to any one person or company, so it's less likely to find a likelihood of confusion. If there's only one word on a trademark good, then it's a much stronger mark. Factor 7, the nature and extent of any actual confusion. So this is evidence of actual confusion among purchasers. I've had clients in the past who have started receiving phone calls because someone has filed a trademark or is using a mark that is highly similar to them, maybe a similar URL name, but a different company, and have received complaints. So that is actual confusion. They're getting complaints about a third-party company to their company because the consumers think that their company is the first company that's infringing their mark and their name. Factor 8, the length of time during and conditions under which there's been concurrent use without evidence of actual confusion. So if you've been operating, two companies use the trademark word for 5 years consecutively and continuously together, and there's no confusion, then probably not a likelihood of confusion. Factor 9, whether or not the mark is a house mark used on a family of products. So the more products it's used on, if it's a family mark or a house mark, then it's more likely to be a stronger mark, more likely for a likelihood of confusion. And factors 10 through 14 are not really pertinent to the registration process, but they are pertinent if you're ever in an enforcement type action, a cancellation proceeding. Essentially, it's any other facts that might be probative of the effect of likelihood of confusion. So that is likelihood of confusion in a nutshell. Thank you very much, and happy trademarking.